My name is Howard Gould. I'm co-chair for the real estate section of the Beverly Hills Bar Association. Want to welcome everybody. Happy that you could all join us today. We are going to have a very interesting and for us a first-time program about cash for keys and how landlords can get relief from underperforming residential units and tenants can have, in a sense, a significant payout potentially if they choose to voluntarily vacate their units. Before we get into the introductions of the program, I want to advise you about what our upcoming programs are going to be. September 18th, we're also doing a new program for us, the intersection of intellectual property law and real estate law. You can learn how copyright and trademark violations can occur without you realizing that your client even has a problem. It's interesting situations where copyright and trademark actually do have a big role to play in real estate transactions. On October 16th, we'll be doing a real property taxation program with Chris O'Neill, who has spoken for us a number of times before. Chris has litigated cases all the way through the California Supreme Court, and he and I have had the pleasure of working together on real property tax issues. November is in the works, and we think it will likely be a program on 1031 tax deferred exchanges. January, probably the 15th, we're going to have former State Bar President Heather Rosing on risk management for real estate lawyers with ethics credit for your MCLE requirements. Heather recently founded her new firm in San Diego and I think is already up to about 17 lawyers. Heather has a long history of assisting lawyers with ethical issues and malpractice issues. February, we anticipate doing our annual review of the prior year's new real estate cases. In March or April, our annual CAR forms program to learn about their changes for 2026. Also want to remind people that if you have questions to post, please put those in the Q&A. In the chat, you can find a link to the program materials, but the Q&A will be used for any questions you want to post during the presentation. Our speaker on the legal requirements for cash for keys is Sasha Struthers. I want to thank Sasha for joining us. She's a California licensed attorney, also a real estate broker, and her practice focuses pretty much entirely on this cash for keys tenant buyouts, which are voluntary transactions. Sasha graduated from Southwestern Law School's SCALE program. She started her career doing employer defense litigation, transitioned into real estate law, and founded her own practice in order to help landlords strategically reposition their portfolios, maximize income, and increase their equities. You can check out her law practice at www.struthers.legal. Eli Appel, our second speaker, is a first vice president for investments at Marcus & Millichap in Encino. Eli has extensive experience selling apartment buildings throughout Southern California, all the way from the Inland Empire through the South Bay, and has a special emphasis in Beverly Hills, where he commands a significant market share. Eli handles these transactions throughout, including underwriting, marketing, negotiating, and closing escrow. His expertise includes tax-deferred 1031 exchanges, allowing owners of investment properties to buy and sell like-kind property while deferring their capital gains taxes. He's been profiled in LA Business Journal, San Fernando Valley Business Journal, Bisno, and CoStar. His bachelor's degree is from UCLA, and he also completed the real estate certificate program with a concentration in investments from UCLA. And with those introductions, can't wait to hear the program.
Fantastic. Thank you, Howard, and the Beverly Hills Bar Association for allowing Sasha Struthers and I to speak about cash for keys. Sasha's going to go through the logistics and the nuts and bolts of cash for keys. And before she jumps in, I just wanted to tell you that when Sasha's done, I'm going to spend about 10 minutes to speak through how cash for keys creates win-win scenarios in the right circumstances for both landlords and tenants. And I'm going to give an example about how, in one particular circumstance, a $30,000 buyout created over $400,000 in equity. Sasha, please go ahead.
Thank you. Thank you everybody for having me. I look forward to this presentation. So I'm going to go ahead and get into it. Let me share my screen. So today's presentation is going to be on cash for keys. Just have a disclaimer, like most attorneys. So everything here today is just going to be for general informational purposes and educational purposes. I might have some anecdotes or some real life examples of things that I've experienced in practicing this area of law, but it won't be specific to your client or your situation. So that's not a substitute for getting legal advice or an independent counsel consultation. My run through of my presentation is pretty straightforward. We're going to talk about what cash for keys is. We're going to talk about the difference between buyouts versus relocation. We're going to talk about when relocation is required, why buyouts are popular, and at the end, we're going to go over some of the buyout requirements in Southern California. So cash for keys in a nutshell is a voluntary lease termination agreement. It's when the landlord and tenant come together, they reach an agreement on specific terms, main ones being what the tenant will receive in exchange for turning in their keys or vacating the unit permanently. The benefits to both sides is that it creates vacancy decontrol for the landlord, so the landlord is able to raise rents, or they're able to at least sell the property vacant or mostly vacant, depending. You can also increase equity either in the form of refinancing or if you're going to be selling the property. Landlords and tenants both can avoid the costly and lengthy eviction process, the adversarial proceedings of being in an eviction, and quite frankly, the uncertainty of it. Landlords and tenants also mutually agree on the money in the move out date, so it's an arm length negotiation. It's not being unilaterally decided for them. The agreement usually involves a release of claims, so the parties are going to be walking away from one another without any sort of tether to further liability. And then lastly, the tenants get a lump sum of money that maybe they otherwise wouldn't have, and that money can either help them relocate, potentially to a nicer unit, to a new neighborhood. Sometimes people relocate out of state or out of country, or just a lump sum of money that the tenant could use maybe for savings or the vacation that they've always wanted to go on. So buyout versus relocation. So cash for keys is also called tenant buyouts. And that's sort of the colloquial term that you use for I'm going to buy out my tenant. I'm going to buy the tenant's basically tenancy. And the term relocation is often interchangeably used. So how buyouts sort of came to be is predominantly in jurisdictions that have rent control. So locally here in Los Angeles, there is several jurisdictions that have their own rent control. LA City has one, LA County Unincorporated, Pasadena, West Hollywood, Beverly Hills, Santa Monica, Inglewood, Culver City. Those are sort of the main ones. There's a few smaller ones. In addition to the rent control, which the rent control typically controls how much you can raise the rent on a tenant. It also controls how and when you can evict a tenant. And more, these controls are being expanded outside of multifamily or apartment buildings. They're being extended to condominiums or single family residences that typically in the past did not have these eviction restrictions. These eviction restrictions are called just cause, no fault, meaning I have reason to evict, but or the tenant hasn't done anything wrong, but I have reason to evict. In those just cause, no fault reasons, the tenant would be entitled to what's called relocation. So relocation is the mandatory amount of money a tenant would get because they are being evicted. They're being given a specific eviction notice to vacate the house, the rental unit. And the city has decided by their own formula that the tenant is entitled to a certain amount of money. So typically, when you go into buyout negotiations, oftentimes you are either required to offer this amount of money to the tenant, or you use that amount of money as a beginning negotiating point because the tenant will look at, well, if I had to move, I would get this money, right? So even though a buyout is voluntary and relocation is mandatory, you typically use the relocation amount for that particular unit as a yardstick or a guiding post or the kickoff for these negotiations. So when is relocation required? Again, no fault, just cause. No fault meaning the tenant hasn't done anything wrong. For instance, they're paying their rent, they're not violating the lease, they're not causing a nuisance, but the landlord has just cause. They have a reason. Typically, the reason is the owner might owner occupy or they might Ellis Act, which we'll talk about a little bit later in the presentation. So in these situations, the landlords would be required to pay relocation. They would be required to provide appropriate eviction notices. And typically, they have to file forms with the city, their declaration of intent, sometimes what it's called, of why they're evicting this tenant. And then there's typically escrow instructions involved and specific rules as to when and how you pay the tenant their relocation money. Additionally, these payments do vary. Each jurisdiction has a different way that they come up with a relocation figure. It could be based on the years of tenancy, could be based on the number of bedrooms in the rental, and it's also can be increased if there are minor children present or living in the unit, if someone is disabled living in the unit, or someone is older than a certain age, usually 60 plus years, 62 plus years. If the tenancy or the units in the tenant meet that kind of criteria, they're typically entitled to a higher relocation payment. So I'm going to go through some of the common no fault just cause situations. So the reasons landlords could potentially vacate a tenant, could evict the tenant, but why they tend to be difficult to achieve in the real world. So owner occupancy is one of the more common ones. Some of the cons about it is that the owner might not want to occupy the property either for themselves or the authorized family member. And the authorized family member does change depending on the jurisdiction. Or they want to owner occupy, but they don't want to owner occupy for the minimum duration. So the minimum duration could be usually typically 1 to 3 years, depending on the city. And so they might need to owner occupy for 6 months, perhaps, or a year, but they don't want to occupy for the full duration. They want to be able to rent the unit back. So they're not going to be able to satisfy the city's requirements. Um, the owner also has to file declarations with the city, so it's additional paperwork that you have to do on an annual basis where you let the city know, yes, I'm continuing to occupy. If you're not occupying it for the minimum duration, like you're supposed to be occupying it, you could run the risk of civil liability. So a tenant could argue, hey, you wrongfully evicted me. You didn't owner occupy for the length of time you're supposed to. It was sort of a constructive eviction. It was misleading. It was bad faith. So you run the risk of being sued by the tenant. Additionally, the newest tenant is typically the first one to go out. So let's say you need a 1 bedroom apartment. You don't get to pick which 1 bedroom necessarily. You have to go to the last tenant that moved in, so the newest tenant, which is likely the market rate tenant. And if that unit is not the unit you want to go after, you have to have a good reason why that unit's not suitable. Maybe I needed, 2 bedrooms, or maybe it's that unit's upstairs and I need a ground floor unit because I have, accessibility issues for myself or the family member occupying. So you have to do a whole analysis on the tenancy in your property. And also there's the issue of, the right of first refusal. Tenants do have potentially a right of first refusal to come back to the unit depending on the jurisdiction. Also, if there's another vacant unit on site that's comparable, you would have to occupy that vacant unit. You couldn't just go pick another tenant. So if you wanted to do this, there's a lot of strings attached to it. And then even if you go through the mental gymnastics of getting the right unit, you have to make sure all your paperwork is done right, and then hope that the tenant actually does vacate. If they don't vacate, then you run the risk that you're going to have to file an eviction to force the notice and to force the tenant out. So even if you have all grounds to do it, it's really up to the tenant if they actually honor that notice. Otherwise, you do wind up in eviction court. Another one is approved condominium conversions. Converting apartments to condominiums is difficult in rent-controlled properties. There's also several overlapping state laws and local laws that if the units are presently tenant occupied, there's restrictions on if you can do a conversion, if you're able to redevelop the property, and there could be increased relocation fees involved with paying the tenants should you want to be redeveloping. So if you're in the early stages of wanting to do a conversion, you might want to have conversations with tenants about doing a voluntary move-out agreement, as it does take several years potentially to get these approved. And yeah, additional restrictions. There's as we sort of balance the tenants' needs for housing and then owners' needs for, higher and best use of their properties or being able to get a return on their property. Some of those things become somewhat in conflict, or they just become very hard to pull off, where you're trying to balance the scales of both the landlord and the tenant. And so condominium conversions are one of those things that get more scrutinized, given we do have a present housing crisis. Then we have demolition. There's the Ellis Act. One part of the Ellis Act is that you're going to be demolishing the property. And the next slide will go over Ellis Act itself. But one part of it is you're demolishing the property. Typically, you're demolishing the property because you're going to be redeveloping the property. So in order to do this, you would have to have, permits and plans and everything gone through plan check so that you have the approved permit to demolish your property. That could take years. Again, if you're going to be demolishing and redeveloping it, depending on what you redevelop, tenants might have a right of first refusal to rent the new units. If you're demolishing it because the unit was in part destroyed, tenants do still have potentially tenancy rights if it's in a rent-controlled property. Again, right of first refusal, right to come back. And if you're going to be demolishing it and you want the tenants out, the tenants may qualify for up to a year if they're disabled or they're a certain age or older. So that also adds to your timeline, your development timeline. The Ellis Act. So the Ellis Act is a state law that allows landlords to go out of the rental business. The other aspect, like we talked about, is you're able to demolish and redevelop. But the Ellis Act, as people tend to know it, is for the prong that you're going out of the rental business and you don't want to rent anymore. So it's typically the option of last resort for landlords. The relocation fees can be very high in jurisdictions. The Ellis Act carries with the property. So even if you Ellis Act and sell it, the new owner is subject to the Ellis Act. And there's certain milestones, 2 years, 5 years, 10 years. If you Ellis Act the property and then you turn around and rent it in a certain time frame, you risk getting sued by the tenant. If you, after, I believe, 2 years, you can re-rent the units, but you have to give the tenants a right of first refusal back at their same rent, I believe, including applicable rent increases. And then after between the 5 and 10 year mark, you're able to go back to renting it. You can get market rent, but again, you're able to, you have to give the tenant a right of first refusal. So there's different milestones that get met. So in the long scheme of things, there's a lot of strings attached with it. Additionally, you can't Ellis Act a unit. So you can't go, this unit is a not performing unit, I'm going to take it off. You have to Ellis Act the entire property and all the units on the property. So it's not a pick and choose thing. You can't kind of mess with it in order to cherry pick tenants that maybe are paying low rent. That's not what the Ellis Act is for, and it's not permitted. So that's the Ellis Act. Again, it's sort of the option of last resort, but it is often one that has to be used, especially if property owners are going to be redeveloping the property and aren't able to reach voluntary move-out agreements. It's the one that does have to get done in order to move forward with that. Another option is a government order requiring the unit to be vacated. These are incredibly rare. I've seen it where it's very hard to get the city or any government agency to mandatory vacate a unit. It usually comes with an order to comply that you have to fix the unit. So even if a unit is destroyed or partially destroyed, depending on the jurisdiction you're in and the pushback you get, you might have to fix the whole unit and then have the tenant come back at their same rent. Again, tenants might have rights of first refusal to come back to the rebuilt unit. the repaired unit. Substantial remodel. So substantial remodel has been virtually removed from most jurisdictions that have their own form of eviction restriction. LA City, being one of the most recent, removed it from non-RSO, but JCO. So not rent-controlled apartments, those already were not allowed to have substantial remodel evictions. But now everything that's not rent-controlled but is residential also you cannot evict a tenant for substantial remodel. So it's been banned in all the residential units in LA City, including houses and condominiums that are only subject to the just cause ordinance. Landlords are not able to necessarily raise rent to market in a lot of these jurisdictions. So if you had to substantially remodel a unit, you wouldn't be able to get market rent for that unit from the same tenant. You might have to just pass through certain charges that are permitted by the city and are typically capped at a certain amount per month. It requires pulling permits. So your permit has to be for electrical, mechanical, plumbing, or structural work. You have to use a licensed contractor. And you also are required, or the work has to take a minimum duration of time. Usually it's 60 days. So between 30 and 60 days, the unit will be uninhabitable for the tenant. Then that would kick in a substantial remodel eviction. However, like I mentioned, it's banned as a grounds to evict a tenant. In most jurisdictions, it's a unilateral option. So the tenant, if you were to do a substantial remodel and you have all the permits pulled and the tenant's going to have to be out of the unit for the 30, 60 days, the tenant can go, okay, I will take permanent relocation, which is defined by the city, and the tenant can opt for that. But again, if the tenant, wants to stay in their unit, they're not often going to opt for it. So substantial remodel doesn't happen very often. And if it does happen, it's not grounds to evict. It's just because the landlord is required to do some sort of repair. But it's for most jurisdictions, it's not an option that's used to evict tenants anymore.
I would like to just note to people that you can get the link to the program materials in the chat and link from there to the program materials.
Thank you, Howard. So why are buyouts popular? For all of the things that I just talked about. So if you're someone who has an apartment building and you don't have a substantial remodel, you don't want to demolish it and redevelop it, you don't want to owner occupy it, the government's not telling you to vacate everybody, but you have maybe a unit that's underperforming in the sense that the rent is really low and there's a huge delta between what the tenant is paying in rent and what market rent is. Landlords are willing to pay tenants to move out, and then they'll do upgrades to the unit so they can compete on the market for market rate rent, and then turn around and rent the unit at a higher amount, and then eventually break even on the investment of buying out the tenant and also the cost of renovating the unit so it's market ready. So it's one of those things that both the landlord and the tenant basically get to be co-piloting this outcome or this situation. There are times where landlords do have grounds to evict the tenant, but landlords don't want to have to necessarily give a tenant a bunch of eviction paperwork and say, here's your check, go, and then the tenant not be happy. Maybe they don't like the relocation amount, maybe they don't like the move out timeline. So to increase your odds of actually getting the vacancy, landlords will try to do a buyout negotiation in advance of that and anticipate it's going to take me time, it's going to take me attorney's fees. I would rather spend the money and buy myself the time as the landlord or the developer and give the money rather than potentially to an eviction firm, give it to the tenant to help the tenant move. And so these are arm length negotiations that happen. There's no real like magic number, like this is the number. There's average numbers, there's numbers that get posted by certain jurisdictions, but they're an opportunity for both sides to come to the table and have a meaningful discussion about, look, this is what I want to do as a landlord, and the tenant can come forward and go, look, this is what I'm facing. My rent is this and my market rent is this. So, there's a delta on both sides. There's an upside and a downside, respectively. And so that's why, you have these conversations. And it's also an opportunity for a tenant who, I've had many buyouts where tenants use the money and bought a house. I've seen tenants use relocation money from, a 60-day notice that they got and got relocation money. I've seen them buy houses. So it's an opportunity. Maybe this buyout money could be the windfall they need to make that down payment on something. I've also seen tenants who are really, hey, I would like to take a buyout because I've been thinking about relocating. I've had older tenants who want to relocate to be closer to their grandchildren. Maybe they're out of state or, in a different county, and that's helped them. I've had tenants who have life changes. They change jobs and they want to move somewhere else, and this money helps them. So there are things that, both sides do have an opportunity. Maybe the tenant wanted to move, but otherwise didn't have the means to do it, and now this is an opportunity. So if both sides are agreeing on it, and it removes a lot of the animosity. Doesn't mean both sides are going to get what they want, right? The tenant might accept less money than they were like really hoping for. A landlord's likely going to pay more money than they were hoping to. But it takes out the animosity, and people can kind of level with one another and go, look, this is both of our respective realities. And you yourselves are coming to the agreement, the landlord and the tenant, not necessarily a court or a jury, so to speak, if it were to come down in eviction. So you get to sort of steer your fate in this. And a lot of the times, these agreements are designed to mitigate further liability and risk. So you want to have it drafted by an experienced attorney. You also want to make sure that any sort of negotiation you upfront are giving tenants, the buyout disclosure. So almost every jurisdiction has a buyout disclosure. So it's a list of rules that the tenants, or rights that the tenants have, rules that the landlord is subject to when approaching tenants for these. That outlines sort of the city is okay with this thing. Of course, they can't stop it, but they want to make sure that tenants have certain rights for themselves and their ability to also, not have a unilateral discussion with the landlord. They want to also know what makes sense for them as well. So we're going to talk about that here in my big, beautiful buyout requirements chart. So some of the requirements of buyouts are, one, they have to be in writing. Also, as attorney, we want everything in writing. It oftentimes has to be bilingual. So if the tenant is negotiating in a different language or speaks a different language, the agreement needs to be translated in that language. A lot of the times tenants do have a cancellation period, meaning the tenant does have a right to change their mind and back out of the deal. So they can, they have between 30 and 45 days is the most common. And they can turn around and change their mind and say, look, I've thought about it. I went and looked at the market and I just can't find anything I can afford. This agreement isn't going to make sense for me, and they can cancel it. Some jurisdictions have minimums, which we talked about earlier, the relocation amount. So some require that the relocation amount be offered to the tenant and not less than that. San Diego is the only one where their code says you have to offer more than relocation. How much more? A penny, a dollar, $100, but it has to be greater than relocation. The buyout agreements do need to be filed with certain jurisdictions if they require it. And there's certain windows of which you have to file it in. And then, of course, you have to give a copy to the tenant. Some of them require that you file a proof of service with the city, that you mail the copy to the tenant. And by and large, buyouts apply to virtually all the residential units, except for LA City. It only applies to their rent stabilized units. So those would be units that are subject to the rent stabilization ordinance that were built, pre-1978.
So on the cancellation period, um, so you can't really do one of these in a week or two. It's going to have to be signed, and then I take it that the cancellation period runs from the date that the agreement is signed.
Yes, so you could do a buyout where the tenant has their move out date, let's say, is August 31st, and today's August 8th. So they have until September 7th to cancel it. And I've had deals where the tenant moves out in a week. And so oftentimes I will have language in the agreement that should you be doing a buyout and I, the landlord, advance money to you, tenant, and then you try to cancel the agreement, you can't do it without returning the money. So oftentimes the money is not handed over, or a portion of the money is not handed over until the cancellation period has expired. Typically it's on handover until the tenant has moved out. So it depends on sort of the trust in this situation. If the tenant has turned in keys, signed a new lease, emptied out the apartment, said, here's the keys, and you hand them a check for, $20,000, and then they come back and say, just kidding, I want to stay in my apartment, they're going to be on the hook for a new unit, this unit, and there's an argument that they actually can't because they haven't turned over the 20,000. So again, that's something where it gets challenged potentially in court with the judge, but there's language in the agreement that addresses that in the event that it's a quick turnaround, the tenant's ready to go.
Sasha, can you give us an idea of what these agreements generally look like, how long they are, any sort of special provisions that some people like to see or that tenants have requested?
Yeah, so the agreement is about 8 pages long. If you're an attorney, not scary. If you're a tenant, it's a lot of homework. That's very, it's not written anything very complicated. So tenants read it all the time. They understand it. They'll ask me questions about it. Typically, what's in there is a paragraph about their rights. There's a buyout disclosure. You received it. Should one apply to this buyout? It talks about that the tenant is how my draft agreement is. It's a waiver of all claims as well. So the tenant doesn't have any further disputes about this. That they're going to be relinquishing their unit. There was, the lease is being terminated. They're giving up possession. They're not going to have any right to come back to the unit under the terms of their current lease or any sort of right to return. The owner is free to do what they want. They can want to sell it. They want to re-rent it. They want to owner occupy it. They want to demolish it, whatever they want to do. It talks about what the tenant's going to get paid, when they're going to get paid, when their term, like their move out date is, the lease termination date. In the event that they don't vacate, what options the landlord has, including their right to evict the tenant to enforce the agreement. And then there's specifics in there about, the tenant will forward their mail. The tenant's not going to move in any other people, and they're not going to try to sublet or assign their tenancy to anyone. That's going to be void. So it's typically the tenant's going to get money, they're going to move out. The security deposit might be addressed in there as well. And then, typical things that you as a landlord want to make sure. And they're like, don't have your friend move into the apartment and now I don't have a vacant unit and I'm stuck with that. So they're all very straightforward things that you would expect in a buyout agreement when the owner's trying to get possession back.
We have a number of questions. One of the questions was, what about the withdrawal from the rental market, just cause? Has that been banned?
The Ellis Act has not been banned. There is no ban on it. Now, if you're redeveloping a property, there are restrictions. There might be higher relocation amounts. There's a state initiative to build more housing, so that might conflict with maybe a local ordinance or zoning that would have allowed maybe going from apartments to condos or something of that nature. But you can at any time exit the rental market. But redeveloping a rent controlled property tends to be where there's a lot of nuance and layers to what is and isn't possible.
Someone wanted to know if Beverly Hills has an ordinance about this.
Beverly Hills does not have a buyout program or ordinance. They're voluntary agreements between the landlord and the tenant.
So that means that you can still do them in Beverly Hills, you just don't have the restrictions of an ordinance.
You can do a buyout agreement anywhere. There's just some jurisdictions that have restrictions about it to help protect and level the playing field for the tenant. Yes.
Another question, does the tenant need to be represented by counsel?
The tenant does not need to be represented by counsel. They have a right to be represented by counsel. They definitely have a right to call that local housing department and ask them questions about buyouts. But they do not have to be, but if they wish to be, by all means, they should have an attorney.
When they are represented by counsel, do you usually include a signature by counsel in the agreement?
No, I think maybe once or twice we had an approved as to form, but typically it's just the parties that sign it.
someone was asking sort of the business question. If there is no relocation amount minimum, what is usually a good starting point for a minimum buyout amount?
I would say typically the relocation amount. If the tenant owes money, so maybe the tenant has arrears and you're like, let me buy them out because I really don't want to go through the eviction process. You might go, hey, your relocation would have been X dollar amount, but you owe me X in rent, so I'll offer you this. Or it's cost me, X dollar amount in attorney's fees or repairs because you've damaged stuff or something. Then you might have an excuse to offer less, but typically you offer the relocation amount.
Um, Sally Roshan, who has a escrow company, has been part of also our executive committee for this section, asks what happens in a situation where the tenant has moved out per the terms of the agreement and the landlord does not authorize the release of the funds that the escrow may be holding.
So there's escrow instructions in that sense. If escrow is holding it, there's escrow instructions. So if the landlord doesn't release the funds, the landlord is risking civil liability for the tenant. And it depends also, at what point in time the tenant moved out. Maybe there's a window where the tenant can cancel the agreement. So it doesn't really behoove the landlord to not pay the rent, especially if you have a buyout agreement that includes a release of all claims. They risk waiving that, and they risk, of course, attorney's fees and civil liability for it. So it's it does happen. It's a shame, but in that sense, it becomes a civil matter between the landlord and the tenant.
How often do you see escrows used in these transactions?
I haven't. I tried getting escrow companies to sort of help with it, and they didn't want anything to do with it. So it's not often that I see escrow companies do it. I sometimes will hold the money in escrow. So if there's a relationship where maybe the landlord and tenant both are like skeptical of one another and like probably rightfully so, then I will hold the funds in my account and then I will issue them out accordingly. And then, should I have what Sally took issue with, I probably would reach out to the state bar and get some sort of guidance on what I, as attorney, should do if I'm holding the funds. But I haven't had it where a landlord doesn't pay the money. They're motivated, in my experience, if they're hiring me, they want to do it right. They don't want to play games. And so they're motivated to give the tenant the money and like, peace be with all.
Have you seen situations where the tenant doesn't move and the landlord actually tries to specifically perform the agreement through the courts?
I haven't had that yet. I've had two buyouts where the tenant canceled. One was during COVID, and it was a buyout agreement where the tenant was simply, the owner was waiving the rent. It was like $35,000 in rent, and the tenant was going to vacate. And the tenant at the time was being difficult and agreed to it, but then canceled the buyout. And my client somewhat expected that to happen, but didn't have an eviction recourse because there was a lot of eviction restrictions and the tenant had canceled the agreement anyways. Then I had one where a tenant had canceled the agreement. Again, it was one where he agreed but couldn't move out and wouldn't explain like when his move out date. I go, okay, if you can't do this date, tell me what date could you do? I don't know. So that one got canceled, and the tenant did ultimately move out. Um, that's to be resolved. Then there was one where a tenant had done a buyout agreement, and he was the main tenant, and his brother had lived with him, and the brother and him had signed it, and the tenant had moved out, but the guy in the unit wasn't the brother. And the tenant had represented to everybody, including the on-site handyman, that the gentleman in the unit was his brother. And that gentleman came forward and said, I didn't do a buyout. I'm not leaving. So my client had to unfortunately do an eviction in that instance as well. Other than that, it's very rare that these things don't follow through with or don't happen, mainly because when you negotiate at arm's length with tenants, even though it might cost you a little bit more, that's the motivation you need for the tenant to uphold the agreement because it has to, again, make sense for the tenant. When tenants don't honor agreements, it's because typically they were forced into an agreement that they didn't like, or they were strong armed. And, that increases the chances that they're going to cancel or just not honor the agreement. But knock on wood, I've yet to have a buyout entirely blow up.
What's the most you've seen or heard about some tenant being paid in one of these?
The highest buyout that I've negotiated, that I've ever heard of, I think was 450,000 in San Francisco. But the highest one that I've ever done was 90,000.
We have a request, and you shouldn't feel pressed to do this, but someone wants to know if you'd be willing to share the agreement form that you use.
I don't typically share it. By all means, if you want to reach out to me or you need an agreement, I'd be happy to talk about it and explain sort of the main provisions in it, for sure.
My old friend Bruce Lorman wants to know about what escrow you might use. And so, Bruce, you might talk to Sally Rochon. It's, I believe, secured trust escrow, and Sally may be willing to do that. She takes on some escrows that other people don't, and she's got a legal background so that I think she's more comfortable looking at those things. And I know other escrows that send her some transactions that they just don't want to handle. Next question. If the tenant is moved out for the owner to move in, and the owner later gets sick and doesn't stay the required period, is there an exception to the penalty or the statutes if they have to move out because of health reasons?
There could be. So the main concern that the city has, or I imagine the judge would or a jury would as well, is the intention at the outset of moving in. So if your goal was to move in because you did genuinely plan to own or occupy, and you did, but let's say you need to own or occupy for a year and your health is on the decline and you need to move back into a unit, own or occupy to be closer to family, and 6 months later you wind up in the hospital bedridden and you can't return to your unit. That would be a good faith argument that like I did genuinely live in the unit. And it's not like I want to be sick, but I ended up in the hospital. So you do have, in that sense, a defense for it. The main thing is that the move-in is in good faith. I mean, you could do a buyout owner. I mean, you could do an owner occupancy and unfortunately pass away 6 months in. And you know what? It's not like it was a bad faith owner occupancy. So that's mainly the argument. And a lot of the times when you do the annual declarations, they'll ask you, are you still living here? And if not, why? I was in the hospital. Family member is deceased.
We have sort of a negotiation question, which is what is the appropriate thing to tell a tenant when the landlord wants to sell the property?
So it depends on the jurisdiction that you're in. A lot of jurisdictions in here, pretty much all the ones that I have listed, wanting to sell the property is not grounds to give the tenant an eviction notice. So you have to, usually you give the tenant, I believe, 120-day notice. Ellie might know, but I believe you give tenants notice of like the property is going to be up for sale. If it's a house or maybe it's a small apartment building and you know the tenants on a first name basis, you might want to have the conversation with the tenant. Go, hey, I'm looking to sell the property. It's going to change hands. Um, would you be interested in doing a buyout agreement, voluntary move out agreement? I would be willing to pay you. And you can open the conversation, and then I would follow up either by dropping off or emailing a copy of the applicable buyout disclosure. But it's always good to like, hey, I want to sell the property. Heads up, you're gonna, entry is gonna have to be permitted, as allowed by the law. And also, if you, would be interested, I'd be willing to entertain a buyout.
So we have another question. What about Civil Code 1946.2J in the TPA that a tenant can't waive the TPA? The cash for keys sounds like a waiver.
I mean, I don't have the code section memorized, so I don't know what the code section is.
Okay.
But it's the buyout agreement is the tenants, when they're entering a buyout, they're being paid to end their tenancy. What the TPA says, I'd have to look at it. But
So
typically,
Bobby, you may want to
Upfront.
contact Sasha offline for that.
yes.
And in case people didn't note it in the Q&A, Sally Roshan says she does do these sorts of escrows. You can reach Sally, emailing her sally@securedtrustescrow.com. Nicole asks to post the seminar handout. I think it's in the Q&A. The link has been put in the Q&A above your question on that one. Okay. What are the strategies for negotiation of more than just the statutory amount for the tenant?
And to go through strategies, it's a very case by case, unit by unit scenario because every jurisdiction has different laws and then every unit has a very different tenancy. You could have someone who's a single adult who could easily move versus someone who's lived in their unit for 40 years and is wheelchair bound and can't easily move versus a family with 2 kids in a really good school district that don't want to move. So it really depends. So the strategy, it's important to have like a conversation with an attorney before you go and do this, because your strategy might vary from unit to unit, and the amount you offer might vary, and then it depends on your budget. And do you want to leave room for negotiation? Are you just going to give them this is the number, take it or leave it? There's different ways to go about it, but that is a very case by case scenario.
One of the questions is, what if you have to move out because the house is uninhabitable for some reason? But I'm not sure exactly where that comes into play in the cash for keys scenario.
I don't know. It depends on if there's an order to comply mandating that the unit be vacated, if the tenant is required. Like it depends on how the government order is written. Whether it's a permanent relocation for the tenant or the tenant has to be temporarily relocated while you fix the uninhabitable issues.
A couple of these are more general sort of landlord-tenant questions, including that one. The rest of it was put in later, that there's a fixed-term lease of 1 year, 6 months, and ceiling collapses. They show mold there, but that's not really a cash for keys situation. That's going to be a question for another speaker, I think, on another time. And similarly, there's a question if someone wants to rent out their condo, but only for 18 months, and then the tenant doesn't want to get out. Again, that's not probably going to be a cash for keys situation. It's really a more general landlord-tenant situation, and will depend, probably, as to how the rent control, rent stabilization affects that right to remove the person, even though it was only a fixed-term lease.
So in short, there's a bunch of offshoots. You might do a buyout agreement because the unit's uninhabitable and the tenant's demanding it. A tenant might go, "Hey, you need to pay me money to move out." That might be a buyout agreement scenario. And then it's basically a settlement agreement. Your unit has some issues with it. You don't want to live in it anymore. You want money. I want to be released of all liability. That could be a buyout scenario for sure. But it all again comes down to what exactly is going on, what's taking place, what is the indicators you're getting from the tenant as to what they want. So there's a lot of nuance if you have just day-to-day disputes with tenants that maybe you just want to do a buyout or the tenant wants to be bought out.
So we need to get onto Ellie's
I
financial
agree.
portion of this. If we have time, we may get back to one or two of the other questions after.
Thank you.
Thank you.
Fantastic. Thank you, Sasha and Howard. Sasha has helped many of my clients create win-win scenarios for both the landlords and the tenants. I'm going to share my PowerPoint. I'm going to share my PowerPoint, which is going to talk a little bit about the financial aspects and also how trusted advisors are able to protect downside risk in many circumstances. So my PowerPoint is going to go ahead and talk about cash for keys and how it creates value, the cash flow break even and exponential return, forced depreciation, refinance and sale, and then how the trusted advisors protect downside risk. Okay, so I got a call from a trust administrator for an apartment building. They inherited a building 5 siblings inherited a building from their father, who was a waiter in Echo Park. And with this tip money over 40 years ago, he was able to purchase an apartment building. He had the opportunity to create multi-generational wealth for his family with tip money. Ultimately, he passed, which was a terrible loss, but he gave his kids an incredible gift. He gave them something called a step-up in basis, which allowed them to sell the building and have limited capital gains exposure. Ultimately, when we got the call, one of the challenges that we had when we were valuing the apartment building is that he was receiving a lot of off-market offers for about $7.5 million. And the reason why is because the occupied rents were around $1,100 a month, which was far below market. We came in, we recognized the opportunity that there could be a cash for keys opportunity after the close of escrow for a buyer. And we went ahead and through the Marcus & Millichap platform, we literally listed it. We went live to not just local, but regional, national, and international buyers. We ultimately found a buyer in New York who was familiar with cash for keys, and he was able to increase, after the close of escrow, increase some of the rents in the building. He was able to offer $30,000 to create win-win scenarios for the tenants who wanted to relocate, and he was able to increase some of the rents by $1,700 a month, which is over $20,000 a year per unit. So I'm going to go ahead and demonstrate to you the cash flow break-even point and the exponential return. So if you have a $20,000 a year increase with a $30,000 buyout, which is a one-time cost, you were able to go ahead and get your money back in 18 months. So the first year is $20,000. The half of the second year, you're getting another $10,000 as a landlord, and the landlord got their money back in 18 months. What is exciting here is that after another 18 months, so 3 years in or 36 months, you got all your money. You got all your money back, plus you doubled your return. So ultimately, you go ahead and get, for a $30,000 payout, you were able to get $60,000 back. So if you thought that was good, or that was exciting, I'm going to go ahead and tell you how it increased the equity in the building, which I call forced appreciation, and which was a tremendous win for the tenant too, because in their case, they wanted to relocate anyway, and they were able to achieve $30,000, which for them was a real economic benefit. So what is NOI? NOI is net operating income. So you take the gross rent of the building minus the expenses, that equals the NOI. So we were able to increase the NOI on this building by $1,700 a month. With a higher NOI, that's a little over $20,000 a year, and at a 5% capitalization rate or a cap rate, that increased the value by $400,000. So what is a cap rate? A cap rate is a buyer's unlevered return, or capitalization rate, their unlevered return. If the buyer puts 100% down in the building, that's their return. There's no loan, so they were able to when you take $20,000, what's the formula for a cap rate? It's the NOI, the gross rent minus the expenses, divided by the purchase price. So with a $20,000 increase, 5%, you got $400,000 of increased value. So now I'm going to go ahead and speak through, it's a $400,000 at a 5 cap, which literally, if you go ahead and have a $400,000 investment at 5% return on that, that spits off $20,000 extra a year. On a refinance perspective, if you're able to go ahead and get a building, let's say at 70% LTV or loan to value, if you have $1 million building and you get 70% out of that, that's $700,000. If there's a $10 million building, the lender is willing to give you 70% loan on that building, that's $7 million. So in this case, if you have $400,000 as an increased value, you're able to go ahead and have an equity extraction of $280,000. That's on the refinance. For that one unit, based off a 5% cap rate for a sale assumption, and there's 5 metrics of value. So cap rate is only one of the financial metrics. If you're able to go ahead and by buying out this one unit, is able to create $400,000 of value on a cap rate perspective. Ultimately, I would suggest everybody speak to a trusted broker or advisor to run through all the scenarios, because this doesn't include remodeling costs, downtime, lost rents, and a number of other factors. And here, I'm going to speak a little bit about how trusted advisors are able to protect downside risk. So many of us in this room, or many of you in the room, are attorneys, and you're advising owners. Some like my grandmother. My grandmother survived the camps. She survived the concentration camps in Romania and Auschwitz, and she came here and didn't have any money, but she worked really, really hard and saved real money. And she was able to buy a small apartment building. And with that apartment building, she was able to work because she wanted to, and not because she had to. But there's a lot of owners like her who live off the income from their building. That's their retirement. And every single month is important to them because that's how they live. So sometimes there's cases where there's an eviction. So cash for keys is a scenario that could help expedite timeframes and eliminate the potential lost rent and uncertainty that with an eviction, which could take 6 to 9 months. So ultimately, cash for keys, in summary, is a scenario where it could help people like my grandmother, people like the waiter in Echo Park, to go ahead and create win-win scenarios for landlords, but also tenants, because there could be a real economic benefit for them if they're looking to relocate, and they could give money which they may not have had otherwise. Thank you so much.
We have another sort of negotiation question that I think is potentially interesting for Sasha. If a landlord is looking to list for sale a residential building, and as their counsel, you have to negotiate with all the tenants, are you going to try to do that collectively or separately? Hope the tenants don't all discuss the terms, the buyout amounts with each other, and how do you approach that to avoid paying more than you need to if you're going to try to approach numerous tenants in the building or even all the tenants?
So, in my experience, before you go and try to list a property for sale, you should approach the tenants for buyouts. Because that's going to give you the best upside on your sale price. I do this typically by offering all the units that it makes sense to in the building. The reason being, if I focus on one, that one tenant's going to feel like, why am I being targeted? And then 2, you're putting all your eggs in one basket. So if you go cherry pick them, it doesn't quite make sense. And it decreases the chances, right? Statistically speaking, if you offer a bunch of people buyouts, you'll probably get 1 or 2. I don't really care that tenants talk to each other. That's fine. They'll talk to each other. They'll go talk to housing. Maybe 1 or 2 will get represented by counsel. Maybe that counsel will represent more than 1 tenant. I don't mind that. For the simple fact that no matter if I go, like me and my neighbor live in an apartment building, we're gonna like negotiate together as a team. But maybe my rent is closer to market. I don't have any kids. And maybe my neighbor, she's a single mom with 2 kids. And her rent is, 40% less than mine. At the end of the day, she's going to ultimately realize, look, you could move. It's not that hard for you. But me, I have kids. I like where I'm at. My kids have been raised here. I'm in a great school district. I have to get more money because I got to look out for me. And that happens all the time in buyouts where the tenant goes, don't tell my neighbor what I'm getting. Like they're on their own. This is for me. And that's basically survival instinct. So by all means, they could talk to each other and they can negotiate it up. But I don't negotiate with groups. And I'm very upfront with tenants. I go, look, what you tell me is your buyout, is your negotiation, and I'm going to take your best points. I'm going to go back to my client with them because my whole job is to get a deal done. So if you have some good points, I'm going to drill those home. If you have bad points, I'm not going to help you in this. But I'm not going to negotiate with you and with your neighbor because you guys have 2 different scenarios, and I think you're entitled to your individual negotiation and your privacy. But if I'm on the phone with the tenant and her neighbor's in there, I can't stop them. I'm not going to like go beat them up. I'm not going to tear them apart. but ultimately they start maybe unified, but they end up breaking off. Also, I will say, if your plan is to buy out to sell, you need to give yourself like months of leeway. And part of what happens is I will come into a buyout where the tenant loosely or the owner loosely started conversations and then they didn't go anywhere. So now the tenant doesn't trust the landlord, so to speak. Or when I come in and I offer relocation, the tenant ignores me. And sometimes my client does have a legitimate ground to move into one of the units, but it ends up becoming difficult because I'm not here to harass and strong arm tenants. I might have a valid negotiating point, like, look, my client's going to own or occupy your unit. Um, or, the whole building is being Ellis acted. And so, this is just an opportunity. But there's times where it becomes difficult for me when I don't always know the big picture. Like, oh, you 3 years ago offered tenant buyouts, and then you got like almost to the finish line and the whole thing blew up. So now I'm coming in trying to save face for you. But I would negotiate I would present offers to everybody. And they, 9 out of 10 times, all go talk to each other about them. Because they'll tell me, we all know we got offer deals. And I'm like, yeah, all right.
Do you ever have purchasers come to you before the purchase to talk about what they think you can accomplish for them on a cash for keys after they buy?
Yeah, tenants do. Our owners come to me, or buyers, sorry, buyers come to me during escrow. Sometimes it's part of the sale contingency that a unit needs to be delivered vacant, and it depends on how the purchase agreement is drafted. So unit to be delivered vacant, but it's sellers to deliver it vacant or buyers to negotiate the terms of which the tenant will vacate. So there's different nuances to it. But I've gone in and I've represented buyers who are purchasing a property or are close to closing on the property and they want to get buyouts done with the tenants.
And someone was asking whether you put confidentiality clauses in the buyout agreements.
I do put confidentiality clauses in the buyout agreements. Like all things, they're enforceable, they're hard to enforce. It could be like I have a buyout and it's somewhat nuanced, and the tenant threw in my face that the guy living upstairs in the same, house but upstairs got a different amount of money and knew exactly how much money the guy got. And it was in the agreement the guy was not to talk about that. But as an owner, you're like, to some degree, like, what am I doing? Do you go find the guy and sue the guy and spend a bunch of attorney's fees? Usually, what it results in is it's really important. Your first buyout is like, it's the metric, right? It's the yardstick. Because no matter how much I could try to put a gag order, if they talk, they talk. The piece of paper only says don't talk. But if they go and talk or they're outside smoking a cigarette and they go, I got 30 grand, like what are you gonna do? Like, the number's out there. So when you do your first buyout, that's kind of how you gauge the rest of them. Because if they get wind of that number, at least you kind of know that's your pain point. Like, look, I'll match it and I'm not going above it. So yeah, there's confidentiality clauses, but like all things, if they don't honor them.
So it may be that if there's one tenant that you're going to have to offer more money to for particular reasons, you may want to make the deal with them after you make it with other people in the building so they're not trying to use that as their yardstick.
Well, there's also an interesting factor, and Ellie and I know about this on a building, but certain jurisdictions post the buyout numbers online. And they'll go, this unit at this address has 2 bedrooms and did a $32,000 buyout on this date because it gets filed with them. So the tenant can just go online and go, hey, and this happened to me. I did a round of buyouts and I did 6 units and I filed them with the city as I'm required to. And so the numbers populated. So a tenant came back to me and she goes, I want the highest buyout and that, or I'm not moving. And I go, yeah, but that tenant has lived here longer, has a bigger unit, and had a better situated unit with a better view. You moved in a few years ago, only have 1 bedroom, and you're closer to market rent. So I'll give you this. And the tenant goes, okay, I'll take that. So sometimes it helps because then, well, this tenant got this number. Yeah, but this tenant has this, and this going in their favor that you don't have. And it's like, if you want the money, we'll talk about it. But it doesn't always mean that you're going to get the highest, biggest number because there's, again, factors involved with that.
We have generated in this a lot of questions in today's presentation, and there are some others, but we're about 5 minutes beyond our time, and I think we'll have to terminate. So I'm going to encourage anybody who wants to get in touch with Sasha privately to if you want to pursue some of the questions there. And just remember that she's talking about cash for keys, not general landlord tenant questions. But other than that, it's been really interesting. It's the cash for keys is a very interesting sort of potentially win-win situation. Very interesting how the equity can get multiplied using cash for keys, as Ellie was demonstrating, talking about just one unit for 30,000. If you had 4 or 5 units in a 10-unit building, you could really get a lot more on selling that building if you get 4 or 5 people to do cash for keys, and can be very powerful. Thank you, Sasha. It's nice to have somebody who does this all the time joining us. Emily, thank you for the financial perspective from the brokerage side of things. And thank you to everybody who attended this month's presentation from the real estate section. Have a great day, everybody, and enjoy the rest of summer.